Mr. Simon, distinguished speakers on the dais, and the august gathering of the dais. Now, whenever I stand up to speak on intellectual property, I am reminded of an incident that occurred to the famous English author Sir Oscar Wilde. Once British Customs asked him, "Sir, do you have anything to declare?" He promptly replied, "Yes, certainly, my intellect." Now, at that point of time, it might be a joke that intellect can be a property, but yesterday's joke is today's reality. It is the highest kind of property that one can have. Now, coming to my topic, Madrid Protocol, which is a tool of the Madrid system. In one word, I would like to place it that in the era of Windows, a new window opens for India. If we can take the advantage properly, it is a huge tool to get protection in multiple jurisdictions through a single window by single filing, single fees, single renewals. Now, what is the system all about? As I said, it's a tool to protect one trademark in multiple jurisdictions. It is more than 90 countries and regions by filing a single application centrally. The Madrid system is governed by two treaties, that is Madrid Agreement and Madrid Protocol. But for certain reasons and certain advantages, the protocol is gaining more ground than the agreement. It is administered by IB, International Bureau of the WIPO, that is in Geneva. Now, how to take advantage of that? Who can apply for Madrid international registration through Madrid? It must be any natural or legal person who meets the following criteria: either a national of, or a domicile of, or has a real and effective industrial and commercial establishment in a state that is either directly party to the protocol or a member of an organization that is party to the protocol. Now, can you directly go and file a Madrid application? No. It has to be based on a prior national or regional registration called basic registration, or a prior national or regional application for registration called basic application. This is another advantage of the Madrid Protocol, because under the agreement it was only registration upon which you can base your international application, but under the protocol you can even base your application under a pending application, or on several prior registrations or applications, provided together they cover the goods and services listed in the international application and the basic application or registration being owned by the same party in the same jurisdiction. That's very important. Now, the trademark office of the jurisdiction that holds the basic registration and or application is called Office of Origin. You cannot directly file an international application to IB. It has to be routed through the Office of Origin. And once, while filing the international application, one of the important jobs is to designate contracting parties. As I said, you can cover multiple jurisdictions through a single application. Those jurisdictions you have to pinpoint and you have to designate. Now, before transmitting your application to IB, what the Office of Origin does is basically certifies regarding the date of receipt, whether the applicant in the international application is same in the basic application or registration, whether the mark applied for is identical along with the basic application or registration. Basically, it's tallying the international application with the basic application or registration regarding whether they are similar in all respects. I'll skip up some slides because of the paucity of time. Now, once it is forwarded to IB, what IB does? IB examines the application, but IB doesn't enter into merit. There is no substantive examination at the international stage. It is just formality checks, like again tallying defect regarding application applicant's entitlement to file, supplying of clear reproduction of the mark, because that's very important, whether there is any shortfall in fees, whether there is correctness in classification, classifying the goods, whether there is any vague terms, in that case objection comes in. Upon doing all these things, once the International Bureau IB is satisfied, it grants international registration. That's a huge advantage of the system. Now, if we compare it with PCT system in patents, that doesn't grant any international patent. That can't be, because it's subject to examination by each state. But here, it's a little ahead. It grants international registration. Now, there might be a question regarding respecting the sovereignty of the contracting states or designated parties. How can you impose a registration upon all contracting parties without checking with their laws and all? I'll come to that aspect very shortly. Upon registration, IB notifies the offices of the designated countries, informs the office of origin, publishes the international registration in WIPO Gazette. And here also, earlier under the agreement, it was only Spanish or French. It might be French. Yeah, French. Now, under the protocol, you have choice of English, French, and Spanish. That is another advantage. It gives you better leverage. Now, what is the date of your international registration? Normally, the date on which the Office of Origin receives the international application, provided the IB receives this within 2 months of the date of receipt by the Office of Origin. So, I am in a very much advantageous position. I filed my application online in Indian Trademark Registry, my Office of Origin, and that is the date of my international registration. See the strength of priority that I am getting. Otherwise, if it is more than 2 months before the IB gets it from the Office of Origin, then the actual date when IB receives the application. Now, regarding key irregularities, I'll again skip because I have to be on time. I have myself reminded here, so it's my duty. So let us keep all these key regularities. Now, protection of international registration. What it is, from the date of international registration, each DCP, designated contracting party, must afford the mark the same protection as if it has been filed directly with the office of that CP, provided there is no refusal of protection, which is called right of refusal. I'll come to that later on, is notified to the IB within the prescribed limit, or in case of such refusals, that is subsequently withdrawn. A provisional refusal need not be final within the prescribed time limit that I am stating about. It is sufficient that the office of the CP notifies the provisional refusal within the set time that yes, I intend to oppose or object, either ex officio, or there might be opposition from my nationals at some point of time beyond that prescribed time. Now, subsequent designation, again I'll skip that. There are more important issues like dependence, central attack, and transformation. I think this is the most important part of the con side of Madrid system that we must be quite aware of. For the first 5 years of registration of the international registration, the validity of international registration dependent on the fate of the basic application or registration. That's very, very important. Now, that is a great tool in the hands of the original adopter and registrant of the mark, original proprietor, to go against deceptively similar mark. Like if a deceptively similar mark is registered internationally designating say 50 countries, it's not required for the original adopter or proprietor to run from pillar to post in 50 jurisdictions to cancel that. If it is within 5 years of international registration, it is enough if the original proprietor attacks the basic application or registration in the Office of Origin and can cancel that. So the international registration ceases to be of any effect in any jurisdiction if or to the extent that the basic application or basic registration falls. What might be the grounds of attacking those basic application or registration? Is On what grounds? On the following reasons: that it is withdrawn or refused, or the basic registration is cancelled, rectified, or the basic registration lapses for non-renewal. Whether the basic application or registration is lost voluntarily or through a trademark office decision or through a court order, really not relevant in this case. The ground or the circumstances leading to the refusal or cancellation being unique to a particular law of jurisdiction, again, is irrelevant. Once the basic application or registration falls, your international registration designating all those countries falls like a house of cards. Now, procedure on ceasing of effect of the basic application or registration. Duty of the Office of Origin is to notify the IB as it is if an action is commenced during the 5-year period dependency that could result in either the basic application being refused or the basic registration being cancelled. Even after the expiry of the period, it is important that the action is initiated within the 5 years period. Even if 5-year period is over after the action is initiated and it takes longer time to be decided, not an issue. Notification to IB of the outcome of such application. Notification to IB regarding cessation of effect of that application, means that basic application or registration. Request to IB to cancel international registration to the extent applicable. Now, on the part of the IB need to record these notifications, complying with the request of the Office of Origin to cancel, publication of cancellations and notifications of pending applications in the WIPO Gazette so that everybody can come to know, sending copies of notifications, etc. Now, this system of dependence for the first 5 years and this option of attacking the basic application and destroying the international registration is called central attack. After 5 years, international registration sort of comes of age and becomes independent of the basic application or registration. So there is a good balancing between good marks, deceptively similar marks, and finally marks getting matured. Once after the initial 5 years is become independent of the basic application or registration, then the validity of the international registration depends on the domestic trademark law of each CPs to which it has been extended. Cancellation of the international mark in one of those jurisdictions does not automatically lead to its cancellation in other jurisdiction after 5 years from the date of international application. That's very, very vital. Now, say for instance, one proprietor loses his international registration due to the lapse of the basic registration or application. Is that the end of the road, or there is still rays of hope? Yes, that provision has also been thought of. You can, if the international registration is cancelled by IB, request of the Office of Origin, on the request of the Office of Origin obviously, the same may be transformed into a series of national or regional trademark application without a loss of priority. So your international registration goes, but you still have hope in all DCP countries, provided the application for transformation is filed within the office of the DCPs within 3 months from the date of cancellation of your international registration. Can only be made for those goods and services naturally regard to international registration. Transformation application is governed entirely by the domestic law obviously, but transformation is not available if the international registration is cancelled by the IB at the request of the holder. I being the holder, if I request IB to cancel my registration, then suddenly I change my mind and I transform it to national application. That's not allowed. Now, the right of refusal that I was referring to, this is the tool to respect the sovereignty of each designated countries. Each DCP has right to refuse protection of the international registration in its territory. Grounds of such refusal must be based on the Paris Convention conditions that would otherwise apply